you're doing well. How is your life? How is family? How is your career going? I hope all is going on well with you. So today we're looking at when an extrajudicial statement is obtained through an interpreter. We're looking at its admissibility, and perhaps you're faced with this issue in court when handling a criminal trial, what you are expected to do, and the objections you can raise in such situations. So I'm Mercy, your host on Lawyers Infohub. Lawyers Infohub is a platform where we talk about law practice. We simplify legal concepts in the most easy and simplifiable way for your clarity and understanding, and to boost you or to help you in your career as an excellent lawyer. Our topic, is something or such that even law students can benefit from. So if you're yet to subscribe to the channel, please do consider subscribing. And for our returning subscribers, we are very grateful for you who always stops by to check what is new on the channel. Now, if you're handling a criminal matter or you're involved in a criminal matter, be you the prosecutor or you are for the defendant, either way, it's good for you to understand certain things so that peradventure another person is raising an objection or you want to raise an objection, you can understand the basis on which you're coming from, and it can make sense to you when certain issues are raised. Now, where the accused statement was obtained via an interpreter, for example, the person does not speak English and the person is speaking in Hausa language or Yoruba language, and the police officer who is obtaining the statement maybe doesn't even hear that language. So an interpreter is now brought in. So there are now three people: the person giving the evidence, or writing out to give his evidence to be written as a statement, the person interpreting, and the police officer under whom he's been directed to give the evidence, or who is supervising the evidence taking. So in that situation, it is obtainable and it is very important that for you who is a prosecutor, that if you want that evidence to fly, the interpreter used in that circumstance must what? Come to court and what? Give evidence as to how he interpreted those things and what language he used to convey what the accused was saying to the police officer who is there to take the evidence. Now, where, for instance, after the evidence was collated or obtained, you come to court and the police officer comes to court to give evidence to say, yes, his evidence was recorded, there was no coercion and all of that. And the interpreter that was used to interpret, remember that the police officer does not even understand what the language the accused was speaking. So it was through the interpreter that the police officer could even interpret what was being said to English. I'll understand it. So it's very important for that third party who is an interpreter to come and give evidence. If not, the evidence of the accused and the evidence of the police officer what is inadmissible. Now, we're going to look at cases where this was applied. Now, in the case of FRN and Usman, this is the 2012 8th Nigerian Weekly Law Report, part 1301, 141. Now, that's where the case started and all of that. Just I'll give you a brief history of the case. Two people were charged with armed robbery, that they shot a police officer who was accompanying a former ICPC chairman to an event. There was exchange of fire shots from the police officers to the bandits. At the end of the day, one of the police officers died. And when they were arraigned, they were arrested and arraigned. They were charged with armed robbery, under the Firearms Act. So one of the High Court, sentenced them to death by hanging. At the Court of Appeal, reversed it. They now went to Supreme Court. Now we're going to read the decisions of the Supreme Court with respect to this issue of extrajudicial statements that is obtained through an interpreter, whether it's inadmissible or not. Now, look at one of the things that was said. Said the police officer that was detailed to obtain a statement from an accused may not understand the language spoken by the accused person. And so the services of an interpreter is needed. The interpreter acts as interpreter between the police officer and the accused person. The interpreter understands the language spoken by the accused person and relays it to the police officer. He speaks to the accused in the accused local language or the language the accused understands, and then relays it to the police officer, and the statement is what recorded. However, before the documents are admissible in evidence, the police officer who recorded the statement and the interpreter it's a must, testify in court. This is what vital testimony. So what is the evidence of the interpreter going to look like? Or what is the interpreter going to see if he's called to testify? So the interpreter is expected to tell the court the questions he asked the accused person on behalf of the police officer and the response that was given by the accused person. It is when this is properly done that it can be said that the truth of the statement has been established. So someone can raise an appeal that the evidence of the accused, the truth of it was not even established. Somebody can also raise an appeal on the fact that the extrajudicial statement of the accused was not what admissible, or the statement or the evidence